Okay, so this is the question that we are going to discuss today. Okay, right? Since you asked to discuss the question on the chapter, okay, human rights. Okay, so this is the one that I managed to get for you. Okay, right? It's from paper 1, set 2. Okay, right? ELS. Okay, from May-June 2015, question 4. The reason why we are looking at 2015 is because the Cambridge, okay, right, hardly ever come out with a question regarding human rights. Okay, right, hardly ever. Okay, right, no matter which set that you're doing, okay, whether set 1, 2 or 3, okay, hardly ever come out. Okay, but it can come out usually as a surprise lah. Okay, right, if you do check out some of my the past year paper analysis, I believe last year or something like that, okay, right, or the year before, it did come out as a surprise. Okay, right, but it's something that I usually tell students to, it's up to you lah, whether you want to prepare for it or not. Okay, all right, so because this is the first time that I'm actually going through a past year question with you, I need to emphasize this to you lah, okay, right, that you need to keep in mind, okay, all the time, okay, every time when we discuss question, and also when you yourself, okay, right, try to attempt question. Okay, right, that is when you look at an essay question. This one is a strategy for essay question. Firstly, okay, is that two things that you need to be concerned with. Okay, right, first one is what chapter is the question covering, and second one is what is the question asking you to focus on or address. Understand that?
Yes.
Okay, right, so now let's look at the question. Firstly, critically examine the effect of the Human Rights Act 1998 on the role of the judges in deciding cases. Okay, so obviously, okay, right, because this thing here is already there already, okay, Human Rights Act 1998, so that is why we know that this question covers the chapter Human Rights Act. Okay, and then secondly, like I say, okay, what is the question asking you to address or focus? You can see here. All right, it basically asks you to critically examine the effect, okay, of the Human Rights Act on the role of judges when deciding cases. Okay, right, so I'm going to highlight this thing, yeah, okay, so that you know. Okay, critically examine the effect. Okay, so the topic is Human Rights Act 1998. The focus of the question: critically examine its effect on the role of judges in deciding cases. Okay, so in a sense, you can actually say that this chapter actually covers, this question actually covers two chapters already. The first chapter is, of course, okay, Human Rights Act. The second chapter, any idea?
Judicial precedent.
Yes, and also sort of like that one. Okay, but that is not what I had in mind. Okay, but that one also can, yes. Okay, what else other than judicial precedent?
Statutory interpretation.
Yeah, actually it concerns more with statutory interpretation than with the judicial precedent. Okay, because if you remember, okay, I've gone through the Human Rights Act 1998, that the human rights chapter with you already. Okay, that one of the things that we learned about was about the Declaration of Incompatibility. Do you remember that?
Yeah.
That the Human Rights Act did provide judges, okay, with an avenue, okay, or something to do, okay, right, okay, if for example that the European Convention, okay, right, or the convention rights, okay, contradict or is different from the local UK law. And the Human Rights Act 1998, okay, right, it actually tells you that if there is some incompatibility going on, judges can actually declare it incompatible. Okay, and then the other thing that it concerns with the role of judges when it comes to statutory interpretation is also, all right, if you remember, okay, how is it that judges can the approaches that judges have when interpreting statute. Okay, do you remember the general approaches to statutory interpretation?
Yes.
What is it? Can you tell me?
The purposive approach
and the literal approach. All right, so these two are the general approaches to statutory interpretation. Right, so the one that that will actually affect, okay, right, judges when in deciding cases, okay, right, is how the Human Rights Act actually goes beyond the purposive approach already. Okay, so that's that lah. Okay, now before I go through with you the structure of actually answering an essay question, okay, we will just quickly look at the markings. Okay, so now that we are looking at the marking scheme, okay, right, we can see that there is band 3, band 4 and band 5. Okay, right, so the reason why I only put these 3 bands here is to show you the, well, band 3 is a bad answer, band 4 is the okay answer, band 5 is the best answer that you're supposed to give. Okay, right, so as you can see here for band 3, yeah, candidate gives a basic explanation of HRA and its effects on the role of the judge in the UK. Right, so basic explanation. Okay, right, so this is what it's trying to emphasize here. Okay, basic explanation, and also, okay, its effect on the role of the judge in the UK. Right, so in other words, that is quite bad. Okay, right, that I mean the level of your answer is actually quite bad, the quality of your answer is quite bad, and unlikely that there to be, you know, any detail of citation of article, section or sections of the act. In other words, that, okay, you didn't actually give any examples at all from the Human Rights Act or from the convention rights. Okay, and then you do nothing more, do little more than rehearse the rights protected by the act. In other words, it's just vomiting out. In other words, okay, right, it is just vomiting out the protected rights only under the act without any substance at all, basically. Okay, and then no analytical, the analytical aspect of the question is unlikely to be considered. In other words, that there is no analytical aspect at all. Okay, right, that you didn't actually critically examine the effect of the Human Rights Act on the role of the judges in deciding cases. That is a very plain answer, and most likely, okay, right, candidates who write their answer, okay, right, that is only of a band 3 will probably consist of like 1 page or less. That is like it's detail and content is very negligible. Okay, so it's very bad. Okay, so let's look at band 4 now. Candidate gives a reasonable explanation of HRA and the way in which it influences judicial decisions. So you can see here reasonable meaning better lah. Okay, right, and also the way it influences judicial decisions. Okay, because you see here critically examine effect on the role of judges in deciding cases. So that's why you need to talk about the way in which it influences judicial decision. Understand that?
Yeah.
Okay, then at the upper end meaning, you know, close to 19 marks lah. Okay, right, of the band there may be references to declaration of incompatibility and the consequences of this. So that's why, remember, right, I did mention just now declaration of incompatibility and also the consequence. The consequence is what? Okay, do you remember that? What is the consequence? It say, for example, that the judge declare that an act of parliament is incompatible with European Convention already. What can the, I mean, what is the consequence of that? Do you remember?
Either the parliament still stick with that act or reform the act.
Yes. Okay, good. Right. Or in other words, okay, that the judges will, you see, the HRA or European Convention will influence judicial decision, and then judiciary, okay, can influence parliament, okay, depending on whether or not parliament wants to be influenced at all lah. Okay, right. Then better candidates may recognize the impact of statutory interpretation and precedent. Okay, so that's why just now I told you, right, okay, that there is actually the discussion on these 2 chapters, but mostly on statutory interpretation lah. Okay, right, because the HRA deals with how judges actually interpret the statute. Like as I say, right, they need to interpret it in line with the convention rights. Okay, right, and the other one is also to follow the decision that was made by the European Court of Human Rights. Okay, right, so I mean, if you want to give more attention to either one of these can, but you know, by the way I look at it, okay, right, it should be, I mean, more attention that should be given to this thing lah. But doesn't matter, okay, at least both should be inside there. Okay, then that's the important thing. Okay, the next one, candidates make attempts to address the analytical component of the question. Okay, which is so it just says here a mixed attempt. That's all. Meaning to say that your effort or your attempt in trying to address this thing here, critically examine the effect, isn't as good as band 5. That's all. Okay, and usually, okay, right, I would interpret this thing as meaning to say that your content is not good enough. Okay, not to say that it's negligible, okay, right? Or it could be negligible in the sense that when you come to the part where you are discussing, okay, right, the analytical component or the evaluative component that time, okay, right, it is negligible. Understand? That like all these things is okay, but then when it comes to this part here, it is negligible. Then you won't be able to get your, you know, I mean, more than band 4 lah. Understand?
Yes.
Okay. Now let's look at band 5. Okay. Candidates give clear explanation of the HRA with good citation of the Act, as in band 4, and an awareness of the impact of statutory interpretation. Basically, it is a rehash of this whole thing with the addition of this thing, that's all. Clear explanation. Or in other words, it has to be more awesome than your band 4, that's all. Okay, together with, you see here, good citation of the Act, okay, and together with the impact of statutory interpretation and also precedent. Okay, more to, so I say here, more to this thing lah. Okay, so that's why I feel it should be more to this thing. That's why I see here, I didn't bother to mention about precedent already, but of course if you mention precedent, it's fine. Okay, then lastly here, candidate clearly addresses the analytical component of the question. So same thing, it just says here clearly addresses as well. In other words, that when you get to the analytical component of the question, okay, it's more awesome than your band 4, that's all. Okay, right, that you give every part of your essay, okay, right, the same good or awesome attention. You understand that?
Yeah.
That everything is very detailed, everything is very clear. Okay, so that's why, okay, right, I always tell students, okay, that on average, this is just a general average, okay, right, it may not apply to you, okay, right, it may apply to certain people only, okay, right, that your answer, okay, right, the length of your answer, okay, should be at least like 4 to 5 pages for an actual awesome A answer. Okay, right, but that will depend on your handwriting and stuff like that as well. So I'm just giving a very general estimate only. Okay, right, because the reason why I say, okay, that your the written content must be that much is because of this thing here. Clear explanation, clearly addressed, good citation. Okay, they can just replace these phrases with awesome, that's all. Okay, they mean the same thing. Okay, so that's why one of the ways to actually ensure that you get an A, this one is based on my experience with students, because I have students who like can hardly write anything and students that write a lot, and usually most of the time, okay, right, those that write a lot, and when I say a lot, it's not just crap, okay, right, it's all relevant, okay, right, things that addresses the things which are very awesome like I say, okay, right, the answer is very awesome, okay, right, then they will be they usually are the ones that come back with an A. Okay, but those who like only can struggle to write 2 pages or 3 pages, it is still possible for them to get an A, okay, right, if the content is spot on, in the sense that, okay, you address everything that the question wants you to address. Maybe the only thing that's lacking is the amount of detail, that's all. Okay, but it is still possible to get an A depending on how exactly it is written. Okay, because like I say, the length of the page and all that I give you, okay, is just an estimate, okay, depending on your handwriting and stuff like that as well. You understand that? All right, good. Okay, so now let's try to come out with a draft. Okay, right, so start off with introduction. Okay, introduction, okay, right, one of the best ways to start off with your introduction is to address the topic of the question, okay, by defining human rights or defining Human Rights Act, for example. Okay, right, so usually what we're doing is to define the topic or chapter that the question is covering. Anyway, you know to copy this thing now, I'll save it and send it to you later. Okay, right, define the topic, chapter that the question is covering or focusing on. Okay, right, okay, so this here would mean human rights and Human Rights Act 1998. Okay, right. And then okay, so usually that's that. Okay, right. And then the other thing, okay, important thing, okay, that I usually try to emphasize is the students, okay, but some students can get it, sometimes they don't get it, sometimes even if they do get it, but then they don't put it in the answer, it's not really a big problem, but it will be good to actually have it there, which is a thesis statement. If you have been following my videos and all that, right, okay, my those video guides and stuff like that, every time I will definitely have a thesis statement there. Okay, and just a quick one, do you know what the thesis statement is?
No.
Okay, now this statement is basically, okay, an overview, okay, or it's like a purpose that you're giving to your answer, right? In which when the reader reads it, the reader will know that, okay, more or less what this essay is going to be doing. And usually your thesis statement will have to address the focus of the question, and the focus of the question is to ask you to critically examine the effect of the Human Rights Act on the role of the judges in this case. So your thesis statement should sound something like this, okay, right? Okay, something like this, okay, right? The Human Rights Act, okay, right, has a lot of effect. So it has affected, okay, the role of judges when deciding cases, right? And to determine that, okay, we need to go through some of the more important aspects of the act, okay, which actually influences, okay, judges, okay, in their judicial decisions, okay, influences judges and their judicial decisions, okay, right? So something like this lah, okay. So basically you can see here from my thesis statement itself, okay, right, basically I'm just saying that we need to find out, okay, right, in order to find out, something like in order to find out how exactly, okay, that the role of judges are affected by the Human Rights Act, we need to go through some important things, okay, right, or aspects from the act itself, okay, that actually influences judges. Understand that?
Yeah.
Okay, right. Okay, right, fine. It will be good for you. I mean, you can see that, okay, that my thesis statement actually addresses the question already, the focus of the question, and of course, it will be good for you to use the words, okay, or keywords from the question itself in your thesis statement, so that you don't run away or run off, okay, digress, okay, in your essay itself, okay, right? Because you can see, okay, thesis statement is following the question, focus of the question. The rest of the essay must follow the thesis statement. Understand?
Yeah.
So that your answer is on point. Okay, you don't talk about stuff which is not relevant at all. Okay, right. So usually, okay, right, I like to break my points, okay, for the essay into a few different points lah. And when I say points, I don't mean paragraph lah. Points meaning like main points. Okay, you can break it up into however many paragraphs that you want lah. Okay, but usually you try not to break into too many paragraphs. Okay. You can also consider one point as one paragraph lah, depending on the kind of essays that you're doing, okay, right? Because sometimes there may be a lot of points, sometimes there may only be a few points that at the end of the day, okay, one point will be talking about more than one thing, and then you need to break them up into appropriate number of paragraphs. Understand that?
Yeah.
Alright, good. So let's start with point 1 first. Okay. So point 1 is usually, okay, right, the developing point. Okay, which basically, okay, it connects the thesis statement with the rest of the essay answer. Okay, And so here usually what you need to do for this question okay, in particular would be to discuss HRA further in detail first, right, and maybe go to its history and purpose. Briefly, I would say maybe briefly go through its history and purpose first, so that once we get to the part where it connects to how it influences judges in deciding cases, the whole thing will make more sense. Understand that?
Yeah.
So just this one here can be like one paragraph, this one point here can actually be like one paragraph, no problem there. So I think that's about it already, right? Now point 2 right, is where you go through some of the convention rights in detail, with some case examples, if possible. So this one here, you can say that it has been broken down into a few paragraphs already, like maybe one convention right, one paragraph, right? So something like that. So this one, if you look at the answer marking scheme, marking scheme. So firstly, we are still here. Explanation of HRA. We are still here actually, right? This paragraph and this paragraph especially, because this is, like I said, the developing paragraph. So this paragraph, right, it's still on HRA only first. Right? Sorry, not this paragraph. I mean this point. Right? Then the next point, will be how HRA and its and the convention rights can influence the judiciary and their decisions. Right? So here is where you go in depth on the discussion of the declaration of incompatibility. Understand that?
Yes.
Incompatibility, and what happens after that in detail. Right? So this is basically the part where we talk about this one here, how it influences the decision. So this one is sorry, actually before talking about the declaration of incompatibility, yes, we have an influence, whereby some of the things that you're supposed to be talking about would be things like how judges must interpret according to the convention rights, and also follow the decisions made by the European Court of Human Rights. Understand that?
Yes.
Then only you get into the part where you go in depth. Go in depth on the discussion of the declaration of incompatibility and what happens after that. Right? So then this is where we are now. Consequences like what you say just now. Right? Like how to say, either leave it as it is, or Parliament reforms it. Understand? Alright, understand?
Yes.
Alright. So there's then yes. So this thing regarding statutory interpretation and precedent. Right. This one Okay, this one we can go into point 4 already. This is basically the point 4. Okay, actually from point 3 onwards lah. Okay, point 3 onwards, it sort of overlap with the analytical component already. Okay, because here it's like we're analyzing lah. We're saying that, oh no, okay, right, if you know how it influences the judiciary, and what is it that the judiciary can do after that lah. So it's sort of, you know, it's sort of getting into the analytical component already, where, you know, you're critically examining the effect. Understand that? Okay.
Yeah.
But then now this one, okay, right, point 4 is where you go in deeper, okay, right, into the evaluative component. Okay, right. So here is the analytical or evaluative component of the essay. Okay, right. So here is where you are, okay, like it says there just now, okay, right, statutory interpretation and also precedent. So here you need to link it to statutory interpretation and judicial precedent. Okay, and how you can do this is, hold on, I think this should be here. Okay. And how you can do this is, for example, statutory interpretation, okay, is whereby you can say that, okay, right, you have to at least briefly go through, okay, SI and the general approaches to SI first, and then come to the part where you actually discuss, okay, the issue that the HRA, okay, seem to encourage what we call that, the judges to go beyond the purposive approach, okay, by literally, sorry, not literally practically okay, right, practically going disregarding a UK law for a European one, something like this lah. Okay, right? You understand this or not? Okay.
Yeah.
Right. So you can say something like, you know, I'm not sure that there was one judge or one of the cases, okay, where it says that they are straining their linguistic capacity or something like that already. Okay, when they actually follow European approach. Okay, right, where it goes beyond, okay, right, just a purposive approach, whereby the literal approach is still looking at the statute itself, the words at least, okay, the words of the statute itself. The purposive approach sort of disregards the words of the statute, but it is still bound by the statute. This HRA, right, okay, and how it affects judicial decisions, okay, right, goes beyond that already. That it sort of disregard UK law altogether. Understand that?
Yeah.
Okay. Then judicial decision, okay, this one not so much. Okay, this one is simply whereby, you know, it would seem that European decisions, okay, can prevail over UK court decisions. Okay, if judges were to be influenced by the the HRA. Okay, understand that? Okay, then there's one more thing. Let me just, the thing that we need to mention, okay, specific acts, because you remember this thing, okay, here, articles or sections of the act. Okay, so this article thing is basically here, this part, okay, if possible. Convention rights, okay, so this is where, where you'll be mentioning some of the articles, okay, right, under the convention, okay, right. Then the part, okay, right, about the Human Rights Act 1993, okay, would be like the section 2 of the Human Rights Act, where it says that, okay, the court must take into account any judgment, decision, declaration, advisory, or opinion given by the European Court of Human Rights. Okay, so this one will be more suitable to here, section 2 HRA, okay, whereby it says that must take into account of any decision made by the European Court of Human Rights. Okay, understand that?
Yeah.
Alright, so that is that. Okay, then the other one, hold on, let me just check and confirm. Section 3 is about the interpretation itself. So section here should be section 3 HRA concerning the compatibility of interpretation with convention rights. Okay, understand that?
Yeah.
Right. So I think that's about it. Okay, and finally you get to your conclusion. That's all. Understand that?
Yes.
Alright, so I'm going to send this thing to you now. Okay, right, then you just have a look, see.
Sir,
Yes,
how many articles are we supposed to mention?
I think 3 should be enough.
3, okay.
Right, because the question here is not specifically on the convention rights. Okay, so this question is not specifically on the convention rights, so it's just a passing note only. That's why I can see here nothing much in your point 2. Understand that?
Yeah. Yes.
Alright, anything else?
No.
No. Okay, good. I tell you what, you can write this whole essay yourself and then send it to me, and then I'll review it. Okay.